Hello and welcome everyone to today's Fenwick Elliott webinar. We're delighted to have so many of you here with us today. My name is Stacey Sinclair and I'm a partner at Fenwick Elliott. And today we are discussing the do's and don'ts of creating and retaining privilege, the practical steps to consider, what is it, and how to ensure that documents become protected by legal privilege and how to avoid any inadvertent waiver of privilege. And I am delighted to be joined today with my colleague, Edward Foyle, who specializes in construction and energy projects and disputes, as well as barrister leading and ranked Richard Osborne from Four Pump Court, who also specializes in construction and energy disputes and projects. And so today, in the usual way, if I could just point out the questions panel, which you should see on the right-hand side of your toolbar. Please do put in questions as we go, and I will try and put as many as possible to our speakers today anonymously. And without further ado, I shall pass over to you, Richard.
Thank you very much indeed. Thank you everyone for joining us for this discussion of privilege. What we're going to do today is focus, as it shows on the slide, on, in particular, legal advice privilege and litigation privilege, as probably the two most commonly encountered. But we'll also touch a little on without prejudice privilege later on. When we're talking about privilege, in very basic terms, what do we mean? Well, as most of you probably know, privilege is a species of confidentiality, the effect of which means that any document which has privilege status is not going to have to be disclosed in proceedings, not going to have to be provided to the other side or to a court. So it's a special sort of confidentiality in that perspective, which protects a document from disclosure. The reason for it, the justification for it, clearly is that businesses can operate effectively if they can take legal advice confident that it will remain confidential to them, and if they can prepare for litigation and take part in litigation confident that the steps they're taking and the information they're collecting won't have to be disclosed to the other side and to the court. So it's clearly very important. It's an area which is easy to state at a high level, but the actual application can be difficult in particular cases, as is demonstrated by the number of decisions which come before the courts on privilege, and the fact that privilege is often an expensive and time-consuming satellite dispute in lots of litigation. It's not easy, and in several of the cases that we're going to talk about today, decisions at first instance have been reversed by the Court of Appeal. So hopefully over the next 40 minutes or so, we're going to go through some of that complexity, explain when privilege is likely to arise and how to maintain it. As I say, we're going to focus principally on legal advice and litigation privilege. There are other forms of privilege, most commonly without prejudice privilege, and also joint interest privilege, which is important to be aware of. So with that, I will hand over to Ed to kick off with legal advice privilege.
Thank you, Richard, and good afternoon, everybody. So I've put on the screen here the test for legal advice privilege. I think the first thing to note is that privilege arises when you create a document. So this is the test you should always have in mind if you want your documents to be privileged. And I know we've got people listening from around the world and outside England, but it's important that you're aware of the English test for legal advice privilege, because if you ever have a dispute in the English courts, they will apply the English test for legal advice privilege, even though you may be a lawyer in another jurisdiction. If your dispute ends up in the courts in England, this is going to be the test that's applied. So the good news is that it's within your own power to make sure that when you create the documents, they are subject to legal advice privilege. The bad news is it can be a little bit tricky because, as we'll see, there are some fairly narrow definitions of some of these requirements. So some tricky issues that you need to be aware of. But legal advice privilege protects confidential communications between a lawyer and a client for the purpose of giving or receiving legal advice. So the issues we'll look at is what is a lawyer, what is legal advice, related to that, what's communication, and the biggest challenge with English law legal advice privilege is the definition of the client. As many of you will know, that definition that's applied here in England is out of step with many other jurisdictions, so something to be aware of. So what is a lawyer? Well, that's fairly straightforward, as you'd expect. It's any member of the legal profession, and that was confirmed by the Supreme Court in the Prudential case in 2013. So that includes solicitors, barristers, members of the Law Society, and members of the Chartered Institute of Legal Executives. It also includes foreign lawyers, and it will include in-house lawyers, but there are further complications for the position of an in-house lawyer that we'll look at in a moment. One thing you should be aware of is that consultants generally will not satisfy this test, and it's easy to think, well, I'm getting legal advice, I'm being advised on my legal rights, but you have to check this requirement as well, that advice is coming from a lawyer. So, for example, in the Prudential case, PwC gave tax advice. Now that was legal advice effectively, but it wasn't being given by a law firm, so by a lawyer, so that advice was not privileged, and you'd expect if that advice had come from a lawyer, it would have been. And I suppose in the construction context, you can imagine similar situations might arise, for example, in relation to health and safety obligations. Consultants' advice would not be privileged, but if it came from a law firm, it would be. Another big area that you should be aware of is the role of claims consultants. Very often parties will engage claims consultants to help with preparation of their case before a dispute, and claims consultants are not or may not be lawyers, so they will not satisfy this test, and you might well have some very interesting documents in that early stage of preparing for a dispute, which the other side to your dispute would be interested to see. So this is the judgment of Mr. Justice Aikenhead in the famous Walter Lilly case, where he confirmed that claims consultants do not meet this test, and that was despite the fact that two of the consultants in question had actually trained at the bar. So legal advice, fairly straightforward. It's advice on the rights, liabilities, obligations and/or remedies that a party may have. And last year, the Court of Appeal in Jet 2 confirmed that must be the dominant purpose of the communication to obtain legal advice. Now, there can be many grey areas here because it will not extend to business advice, even if that is given by the lawyer. And this can be a particular issue for in-house counsel, as they will, as I understand, often be performing an administrative function or an advisory function without necessarily giving legal advice. So this is where in-house lawyers, I think, need to be particularly careful to consider whether what they are actually doing is providing legal advice. And it has to be a communication. So it doesn't have to be the final communication giving the advice, the note that comes from Fenwick, Elliott or Four Pump Court with our with our name on it saying our advice to you is X. It's also the exchanges that lead up to that advice, give the context and background that then form part of our instructions that we can then advise you on your rights and liabilities. But again, in-house lawyers need to be particularly careful to consider whether they're being asked to advise on the law or whether they're being asked to advise on something else. And it's really important that members of the commercial team appreciate that just copying a lawyer does not make a document become privileged. In particular, you can have many people as recipients to emails, one of whom may be a lawyer. And the court, in determining whether that document is privileged, will look at what it goes to. Is the lawyer being asked to advise on legal issues, or is it perhaps directed to the commercial team and they're being asked to advise on commercial issues? That is, again, the confirmed in the Jet 2 decision last year, that you must look at each email or correspondence and decide what it is in substance. So, and identify the dominant purpose. So I suppose a tip there is if you're an in-house lawyer and you're not sure whether there's a chain of communications requests going on, you're not sure whether legal advice privileges are rising, it's much better to start a fresh email, respond with a new one saying, you have asked me to advise on, and that really will maximize the chances that you're going to be protected by legal advice privilege. The papers created by lawyers, which ultimately lead to the advice that they're given, are an exception generally to the requirement that there's a communication. So drafts produced by a law firm will not ultimately need to be disclosed. The exception to that is documents that do not give any advice at all. They just record facts. They don't betray the trend of the advice given. So this could include verbatim interview notes, which, as we'll see in the context of, say, an investigation, may not attract litigation privilege. So I think you should always, as a starting point, think, are you going to get legal advice privilege? Because that's within your control, and see if you can satisfy that test. And as I say, just a pure note of a meeting of which no advice is given may not attract legal advice privilege. Now, as I mentioned earlier, it's the definition of a client that creates problems for legal advice privilege. It's a very narrow definition. It's only those persons within a company that are specifically tasked with obtaining legal advice, and other employees within a company are effectively treated as so-called third-party employees. Communications between those third-party employees and a lawyer are not privileged, even if those communications are treated for the purpose of giving or receiving of legal advice. So this is the well-known decision of the Court of Appeal in 3 Rivers No. 5 back in 2003. And the quote there is on the bottom of the screen: communications between an employee of a corporation and the corporation's lawyers cannot attract legal advice unless that employee was tasked with creating and receiving such advice on behalf of the client. Nobody likes this decision, least of all the Court of Appeal, who've been very critical of it. Excuse me. And this is the Court of Appeal in Jet 2 last year, criticising the basis for that decision as being unsafe and without any of the principled analysis of legal advice privilege which has subsequently taken place. It's also criticised for being out of step with other common law jurisdictions, but really it's this issue that the world has changed and nowadays companies are much bigger, and the feeling in the judiciary is that this test really penalises large corporations, because the number of people who will be responsible for receiving legal advice within those corporations will be much smaller, than may be the case in a smaller organisation. More people will receive it. So just to demonstrate how this issue plays out, in this slide on the screen, the red circle represents the entire client organisation. So that could be a large PLC company, or indeed any company, but it could include many employees. The C is the group of individuals tasked with obtaining legal advice, and the E is the so-called third-party employees. So communications between the lawyer, external lawyer, and the client as defined will attract legal advice privilege, but any communications between an employee and the lawyer will not attract legal advice privilege. And it actually gets more complicated than that, because as shown on the second slide, I've now tried to portray that the employee in this circumstance is exchanging information with the client with a view to then receiving legal advice from a lawyer. And those communications between the employee and the client are relevant, very important to settle the instructions that the lawyer will be given and asked to advise on. However, they're not communications between a client and a lawyer. They are communications between a third-party employee and the client. So even if the client receives those documents, receives an email from one of these third-party employees and forwards it to Fenwick, Elliott or Foyle Pump Court and asks for advice on that email does not become privileged by virtue of being forwarded to a law firm. It is not a privileged document. So if you are within the so-called core client and you are obtaining legal advice, you need to think very carefully about how you are going to settle the law firm's instructions. And it may be that you should be conscious about creating unnecessary records. It may be that you need to speak to those within the commercial team and then write up the records of your conversations and then create this document yourself that will then go to external counsel. That is the way to get around this issue. The other pitfall that you should be wary of is if someone in the client has a telephone call with an employee, writes up working papers in order to then send to external counsel, but doesn't actually send them, maybe sends some later, more refined version, those documents that were not sent, they were never communicated, so they also do not pass the test for legal advice privilege. So this really does show the challenges that the definition of client throws up, and really what you must be aware of. I'd also just say, for those of you that are in-house counsel, it's unclear, there's no authority on whether, if you're an in-house lawyer, who your client is, whether it's specific individuals, perhaps heads of department within your company, or whether any member of your company can be considered your client. There's no authority, but you should perhaps, if you're giving advice to somebody in an in-house role, you should just think about that and try and set up a paper chain to establish that you are allowed to consider that person your client for the purposes of legal advice privilege, that is. So some practical tips. Well, ultimately, the court is going to decide as a question of fact who the client is. they'll look at the evidence. So you need to try and make a record of who those individuals are that are tasked with giving and obtaining legal advice. Just to reiterate, it's only those individuals. So it could be that very senior individuals are not within that core client, and therefore their communications won't be privileged. That was the case in the Three Rivers decision, that the governor of the Bank of England was not, his communications with Freshfields, who were working on the Bingham inquiry with the Bank of England, the governor's communications with Freshfields were not privileged because he was not tasked with giving and receiving legal advice. It didn't matter that he was top dog. So that's something that you need to define, keep under review, and just avoid creating unnecessary records, I think, so that you can get over those challenges that I mentioned. So I think we'll now move on, Richard, to litigation privilege.
Brilliant, thank you very much, Ed. So on the slide, we've put the probably best known explanation of what litigation privilege is and the requirements for it. It's Lord Carswell's speech in Three Rivers, and this is the pithy summary which the courts often return to when they're looking at issues of litigation privilege. He sets out there three requirements. Firstly, litigation must be in progress or in contemplation. The communications must be made for the sole or dominant purpose of conducting that litigation, and the litigation must be adversarial, not investigative or inquisitorial. Now, a few things to note about, sorry Ed, can we go back? A few things to note about that. Firstly, you'll see that Lord Carswell talks about communications between parties or their solicitors and third parties. So the involvement of a lawyer is not a requirement for litigation privilege to arise. Second thing to note is the privilege exists and maintains whether or not ultimately litigation does result. The maxim is once privileged, always privileged. So if litigation was in reasonable contemplation, but didn't in fact happen, that won't negate the fact that the relevant documents are privileged. And the third point is that the same requirement of confidentiality as exists in relation to legal advice privilege exists here. So for example, notes of a conversation with the opposing side to a dispute would not attract litigation privilege. Notes of public hearings would not attract litigation privilege. So looking at that, there are a number of issues. Firstly, what are adversarial proceedings? Secondly, when are they reasonably in prospect? And thirdly, how do you judge the dominant purpose of a document? So starting with that first question, what are adversarial proceedings? Well, litigation, clearly no difficulty there. Similarly, arbitration has long been held to fall within the scope of litigation privilege. Adjudication has a question mark next to it because a lot of the textbooks maintain that there is some question around adjudication. The reason for that is because the role of the adjudicator is often said to have some inquisitorial features, because the adjudicator has the ability to take the initiative to ascertain the facts and the law. In reality, I don't think there's any serious doubt that adjudication is an adversarial proceeding. Certainly those of us who are involved in them would attest to that fact. They simply feel pretty adversarial most of the time. And in fact, this has been assumed in a couple of cases in front of the TCC, although not, so far as I'm aware, expressly decided. Where there are real question marks and really fewer hard and fast rules, the last two categories on the slide, expert determination and investigations, and regulatory investigations in particular. So expert determination has been looked at by the court. Very common to have expert determination as the format for dispute resolution under a contract. There is, what we can say with confidence, there is no general rule that expert determinations and documents prepared for the purpose of an expert determination will attract litigation privilege. Now that is because it is not always clear that an expert determination is an adversarial process. And that was identified by the court in a case a couple of years ago called WH Holdings. It will depend on what the contract says or what the parties have agreed about how the expert determination will be conducted. It may be clear from the contract or from the parties' agreement that an expert determination will adopt an adversarial approach, but it may not. And if the contract is silent as to the process, then the court will not necessarily, certainly didn't in the WH Holdings case, assume that that process will be an adversarial one. So if what you're preparing for is an expert determination where it's not clear precisely what process is going to be adopted by the expert, you can't have confidence that the documents being produced are going to be litigation privileged. Investigations is an area which has come up a few times in the courts. Now this, of course, can be a very important category for clients, because if there is a suspicion of wrongdoing or fault, very naturally a client is going to want to investigate, and it may well not want to necessarily share the outcomes of those investigations with third parties. So in that kind of context, there are going to be two questions. The first is, are you in or contemplating an adversarial process? And secondly, is the dominant purpose, if so, of the documents being produced that process as opposed to anything else? So just going on to a couple of the cases, these two cases which reached ultimately quite different conclusions on their facts. The first, the SFO and ENRC case, the facts of that were December 2010, an anonymous whistleblower sends an email alleging wrongdoing within a subsidiary of ENRC. 4 months later, April 2011, external lawyers are instructed to investigate, and a few months after that there's a letter from the SFO. The SFO opens a formal criminal investigation only 2 years later. Now the High Court at first instance found that the SFO investigation did not amount to an adversarial proceeding. And in essence, the quote is there on the slide, the judge viewed it as a step preparatory to a prosecution, which itself clearly would be adversarial, but her view was that the investigation had to be conducted and completed before there was a decision to prosecute. So her approach, as set out on the slide, is that criminal proceedings cannot be reasonably contemplated unless the prospective defendant, can we go back, knows enough about what the investigation is likely to unearth or has unearthed to appreciate that it's realistic to expect a prosecutor to be satisfied. So that was quite a striking conclusion, that effectively privilege was likely to be attracted by entities who knew or suspected that there had been wrongdoing, rather than parties who didn't know and were investigating to try to find out, which was a very striking finding, at least as I read it. That then came, that issue broadly came before the Court of Appeal in R versus Jukes. That was a criminal prosecution concerning a fatal industrial accident, where Mr. Jukes worked at a waste recycling company. An employee of that company was fatally injured in a nasty accident. He gave a witness statement 2 months after the incident to external lawyers, in which he acknowledged that he was responsible for health and safety at the company. Now, a year and a half after that, the HSE was investigating, and Mr. Jukes gave a statement in which he denied that he was responsible for health and safety. Now, in the prosecution against him, that first witness statement was unearthed and was used as evidence that he was responsible for health and safety, and he objected to that evidence having been admitted on the basis that it was privileged. Now, the Court of Appeal rejected that on 2 grounds. The first one was to do with who owned the privilege, even if it existed. And they effectively said, well, the holder of the privilege was his employer, not Mr. Jukes. So he wasn't able to take advantage of that. Any assertion of privilege had to come from the employer, not from him. So that disposed of it. But they went on to say that they agreed with Mr. Justice Andrews in the ENRC case. And they said an investigation is not adversarial litigation. And you can see the quote there. So the view seemed to be very much that investigations were not adversarial and were unlikely to engage litigation privilege. But then, if we go on to the next slide, ENRC itself went to the Court of Appeal, and very shortly after, the Court of Appeal had endorsed the first instance decision in ENRC. It was overturned by the Court of Appeal, and you can see the conclusion which was reached by the Court of Appeal on the slide. They say it was not right that there was that general principle. And in fact, they say the fact formal investigation has not commenced will be one part of the factual matrix, but will not necessarily be determinative. And what the Court of Appeal did on the appeal in that case was look very closely at the evidence as to what had happened at particular points in time, right down to particular emails sent by those within ENRC concerning the process they understood themselves to be within, what was happening in that process, and ultimately reached the conclusion that the materials produced, which they sought to withhold from disclosure, were covered by litigation privilege. So the upshot of all of this is that I think it is now, there are a few cases which indicate that you are certainly able to assert litigation privilege in respect of investigations. Whether such a claim is going to succeed in particular circumstances is, I think, going to come down to the precise nature of the investigation or the process that you're in, the penalties that might be faced at the end of it, what is known of the attitude of the agency investigating, if it's an external agency. And I think potentially knowledge of what has happened is a relevant factor, but certainly not determinative in the way that was suggested at first instance. So that's adversarial proceedings. The next question is, when are they in reasonable contemplation? Now, the leading case on this is USA and Philip Morris. This is one of those things where the test has been put in various different ways. It's quite difficult to pin down, and applying it to particular facts is always going to be a matter of looking very closely at the precise situation the party is in. But what is clear is that mere possibility, general apprehension, a distinct possibility that sooner or later someone might make a claim is not enough. In that particular case, it was held not to be sufficient that a lot of other tobacco companies had been sued on the basis of their historic knowledge of the dangers of tobacco. Simply the fact that that had happened to other companies in the industry, and the fact that that justified a distinct possibility that sooner or later there would be a claim against Philip Morris, was not enough to say that proceedings were in reasonable contemplation at that stage. And then again, the quotation we put on the slide from Starbev and Hamblin J. It doesn't have to be a chance greater than 50%, but it has to be a mere possibility. So clearly a continuum, and it will be a matter of fact as to where on that continuum a party falls at any particular space in point in time. But those are the broad guidelines that we get from the cases. One thing I would say on reasonable contemplation, just to finish that point, in the context of construction projects in particular, one area where this often arises is that on construction projects, one or other party will bring in external experts, QSs, delay analysts, to assist them in putting together or ascertaining their entitlement under the contract. Now, I think some care has to be taken with that, because in order to be litigation privileged, those steps are going to have to be preparatory to an adjudication or an adversarial process. And it may be very difficult to say that if what is actually happening in substance is the preparation of a claim which hasn't yet been put, potentially, let alone disputed. So difficulties can arise, I think, and people can overestimate the breadth of litigation privilege in circumstances like that, where care is going to have to be taken if privilege is going to be asserted. So next question, what is the dominant purpose? Now, the dominant purpose, if you're going to assert litigation privilege, must be use in litigation, the conduct of it, or material for deployment within litigation. Dominant purpose doesn't have to be the only purpose, but it is clear that you will not benefit from litigation privilege if there are two purposes or multiple purposes, all of which are of equal importance and only one of which is litigation. So there's a case which we put on the slide, which I hope illustrates this point. It's the Sotheby's case. Now, what had actually happened in this case is Sotheby's had sold a very expensive painting to a third party. The third party had come back some years later and said that the painting was fake and that he was entitled to rescind the contract of sale and get his money back. Now, Sotheby's, faced with that, commissioned an expert report to try to figure out whether this painting was fake or not. And it was found that it did that for two reasons. The first was to decide whether it should agree to the rescission of the buyer's contract and return the money. The second purpose was for use in contemplated litigation against the original seller. Now, the court concluded that each of those purposes was of equal importance, and so there was no litigation privilege. And that was the case even though, if the non-litigation purpose, if you like, the commercial decision of should we agree to the rescission of the contract and return the money, if Sotheby's concluded that they weren't prepared to do that, it would be inevitable that there would be a dispute arising from it. And that's reflected in the quote on the slide. So that I think illustrates this dual purpose, that ultimately a dual purpose will not be enough and will not meet the dominant purpose test, which has to be litigation. So finally, just tying up this bit, ways in which one can try to make the position as clear as possible to avoid disputes later. If, as I say, in the ENRC case in particular, the Court of Appeal looked very closely at what was known at particular points in time in order to try and evaluate the assertion of privilege. if you are in a position where you think proceedings are reasonably in prospect, it is very sensible to make a record of that fact and explain why. If documents are being created for the purpose of an anticipated litigation process in the broad sense I've talked about, it can be helpful to mark them as such. Now, the courts can be sceptical of the way people mark their documents, and things like without prejudice can appear on documents wholesale. And the courts will apply a critical eye to that. But nonetheless, it can help if you feel, as evidence that you felt you were in reasonable contemplation of proceedings, to mark that. If you've taken steps consistent with impending dispute or litigation, like hold letters, then that is a useful thing to do. In terms of, of course, I've gone far too long. In terms of ways to avoid losing privilege, the most common type of dispute which I come across is to do with waiver of privilege. And in particular, that most commonly arises where people have referred to privileged documents in the course of disputes. And the rule there is if you are revealing the content of a privileged document in a way which makes it unfair to withhold the remainder or associated documents, that may amount to a waiver. So if you are ever in a position of talking about material which is privileged to a third party, in particular to the court, it pays to be very, very careful and very circumspect about the way that is being done. And I think Ed's now going to talk at lightning speed about sharing documents.
I will. Well, one thing, Richard, I'd just add to your tips about avoiding privilege, and when a court might find that litigation is reasonably in prospect. I think appointment of external counsel is a factor, isn't it, that might influence them, not a determining factor, but a factor that might influence them in their decision making. And it's also, of course, something I should have mentioned as well. You're not going to get legal advice privilege unless you involve a lawyer. So involving lawyers is a way, to really help ensure that you're going to get privilege. And if it's external lawyers, then I think that just makes their involvement that bit more clear cut for the court to see that.
Well, and the court can look quite closely at the scope of the instruction, because yes, precisely as you say, it may be clear from that instruction that it's being implemented on the basis of anticipated proceedings or in contemplation of proceedings. So that can be very helpful evidence of the position that the client is in at that point in time.
Exactly. Right. So at light speed, once you have your privileged material, how can you use it and ensure that you're not going to be waiving it? Well, the important thing to remember is, as Richard mentioned at the very beginning of this talk, privilege is all about confidentiality. So however you share it, you must ensure that confidentiality is retained. If you want to be very, very careful, you can consider getting confidentiality undertakings from those that you share it with. We're only sharing it with you on this basis. Otherwise, I think it's probably sufficient just to say, please keep this, please ensure that you will keep this information as you share it. It's much easier to determine that privilege still arises if you forward the advice itself, rather than try and summarize what it says or try and say we're going to make this commercial decision based on the advice that we've received. I think things can become a little bit blurred, and that's something to be careful of. But the issues that I mentioned earlier about the definition of the client aren't the problems aren't as acute, because you can share it once received in a way that it sort of goes against what I was explaining about how you should instruct lawyers. So it's actually it's a bit of an odd situation, but you can share it. You just need to be careful about the way that you do. and you need to be aware that sharing legal advice, if you are tasked to receive legal advice, you receive it. When you then share it with others in your company, you should do so on a confidential basis, because they are not the client receiving the legal advice. So do be aware of that. Just some examples on the screen of when you share that advice, at what point does it lose privilege? Well, in most cases, if you are directly reporting legal advice, that's fine. But as you can see, the last couple of points on this is in the context of a meeting, the last couple of points are where you need to be a bit careful. So if you're recording what you're going to do in light of the legal advice, that will not be privileged, and that's something you must be careful about. And equally, it may be that sections of the meeting minutes would be redacted on account of them giving the legal advice, but then the actions that you might say we're going to take afterwards would not be redacted, because they are not the legal advice, they're the steps that you're going to take afterwards. So that just shows the care that you need to take on that slide. And I'm conscious of the time, so I know there were a few questions, and I think we'll move on to those, Stacey.
Richard and Edward, thank you very much, and that's been brilliant. And don't worry about the lightning speed. Your very clear and detailed explanations have actually captured a number of the questions that have been coming in from the audience. So thank you so much, and thank you hugely to the audience for the questions that have come in, which we can field a few right now. I'm going to take the first one myself, actually. The question is, will these slides be available and where? We've had a number of you asking, so thank you. Yes, they will be available. The slides and also an on-demand recording of this webinar will be available on our website. And the way you get to them is you go to Research and Insight and then down to Past Webinars. And there you can see all of our past webinars with both the slides and the recordings. So thank you for those questions. So the first question, Edward, I'm going to try and pick a few from the number we've had. Edward, I think is for you, and it touches on what you've spoken to already. Can the issues with third-party employees attracting legal advice privilege be resolved by having an in-house lawyer as part of the inner client?
That's a good question. So I think what that's going to, if I just not sure I have control. I think the question that's being asked there is, well, in this scenario on the screen, what if the in-house lawyer was part of the core client team tasked with obtaining legal advice? Do their communications with the members of the commercial team, where they're seeking to settle the lawyer's instructions, get legal advice privilege because they are a lawyer here governing this communication? Actually, they don't, because it's not the in-house lawyer that is giving or receiving legal advice. It's this lawyer over here. So surprisingly, that doesn't resolve the conundrum. That's the Glaxo-Wellcome decision in 2018. It says that it doesn't matter, because it's not the in-house lawyer that is receiving the advice. Sorry, that they're not making the communication in order to obtain the advice. So that's
perfect.
Not going to help, I'm afraid.
Edward, thanks for that. Let's move on to another question. One for Richard, possibly, maybe both. Given the absence of disclosure, in your experience, do privilege disputes ever arise in adjudications?
I'll take that one.
Richard?
Yes, is the answer to that. I've certainly had experience of it. Very commonly, you can have, in particular, without prejudice disputes, because by their nature, those documents are in the hands of both parties. And I've had it several times that, particularly when parties are coming into conflict with each other and becoming sensitive, all manner of documentation starts to be marked without prejudice, almost as a matter of course. And then once you get into an adjudication, one party will want to rely on a document marked without prejudice, the other side will object, and you will have to try and resolve that dispute within the confines of an adjudication. Less commonly, you may have a situation where one party knows that the other has got a certain species of document within its possession because, for example, it knows that during the course of the project it had external third parties coming in to assist it, experts in particular, and will ask where those documents are if they're not being produced. There you can get into an argument about whether those documents ought to be produced, whether an assertion of privilege is correct. And ultimately, there is no disclosure. Your options for forcing the issue are limited, but of course adjudicators can draw adverse inferences from the absence of documents which they conclude ought to be available and could be provided. So yes, these disputes do come up. Another one actually which occurs to me is you can have situations when one party has access to, for example, documents that have come into its possession through taking over premises or something, and privilege disputes can arise in relation to those. So there are ways it can be fought out in adjudication, but obviously the facility to force it to a final decision just isn't there in the way it is at court.
Super, thank you, Richard. Let's squeeze in one more. I'm conscious of the time. Does a claim to an engineer attract litigation privilege?
One for you, Richard, again, I think.
Again, I think it comes down to the principles that we talked about on the slide as to what an adversarial proceeding is. It's all going to come down to the particular circumstances in which a claim is being made and the way it's going to be adjudicated on. That's the critical thing, whether it falls within adversarial litigation or not, and the principles we've talked about with expert determination come into play. If the contract does not expressly provide for some particularly adversarial process, I think it could be an uphill battle to say that you're in a situation where litigation privilege is going to come into play.
If you're following Mrs. Justice Andrews, you don't know until the engineers rejected it, and then.
No, absolutely. Okay, thank you again, both. I think that's all the time we have questions for. Clearly a complex area, and the audience, thank you for all your questions and feedback and comments, which have been very lovely. So thank you for putting those in as well. So just a bit of a pitch for our next webinar, which will come up in 2 weeks' time on the 25th of March. We have an adjudication update where our partner Jeremy Glover, if you have been tuning in week on week, you will have seen Jeremy on a number of our webinars. Jeremy is going to be leading a discussion on an adjudication and the latest updates in case law and developments, and I will be pitching in, as well as George Bodie, one of our colleagues. So do tune in if you can in 2 weeks' time. The other thing I just wanted to mention, when you exit the webinar today, there is a survey, and if you are particularly interested in any topic that you'd like to see on one of our upcoming webinars, please do type that into the survey, and we'll try and incorporate that as we go. But Richard, Edward, thank you again for today, and thank you to our audience for joining us, and we hope to see you again soon, maybe in the not too distant future in person as well. So thank you, everyone. Stay safe wherever you might be, and see you soon.